Thank you for joining Gowling WLG for this Employment, Labour and Equalities podcast. We are an international law firm working in major sectors including energy, life sciences, infrastructure, financial services, real estate and technology. Our episodes cover the latest developments relevant to you across different sectors and services. Make sure you subscribe to receive the latest episodes of this podcast. Visit our website, gowlingwlg.com, for all of our latest insights.
Hello and welcome to the Gowling WLG Employment Law Review, our 2021 top picks. I'm Connie Cliff, a Principal Associate here at Gowling WLG, and I'm being joined today by my colleague who is also a Principal Associate here, Siobhan Bishop. 2021, another year dominated by COVID-19. In 2020, for many, the employment words of the year were home working and furlough. While furloughs continued to feature heavily for much of 2021, the end of September brought the winding up of the coronavirus job retention scheme. Following the vaccine rollout, the 2021 employment phrase and word of the year became no jab, no job, and for many, hybrid working. Though home working is again making a last-minute sprint finish in 2021. As for the world of work, it's continuing to evolve. Uncertainties remain high as new COVID-19 variants emerge, but for now, as 2021 draws to a close, we're going to sit back in front of the telly with a light heart, well, as much as one can muster in the midst of a pandemic, and reflect on our pick of the 2021 employment case law highlights, and of course, our 2021 awards. Now, this year, we're going to begin with employment status. So 2021 brought the final season of the long-running Uber litigation and even more. So let's start with some 80s US soap classics. Over to Siobhan.
So we're here with Dallas Status, beginning the year with the Supreme Court answering the employment law equivalent of who shot JR, being what are Uber drivers. Back in February, the Supreme Court, in the long-running and high-profile case of Uber, upheld the finding that Uber drivers are workers for the purposes of the Employment Rights Act, the Working Time Regulations, and the National Minimum Wage Act. The Supreme Court agreed that the contractual documentation did not reflect the reality of the agreed working relationship. But, as with every long-running saga, there was a twist. The contractual documents were not, in fact, the starting place. Whether or not an individual is a worker is primarily a question of statutory interpretation, not contractual interpretation. When you are deciding whether a particular worker is a worker, you do not start with the contract and see whether that is the sort of contract which a worker would have had. Instead, you start with the statutory provision, for example, the right to a minimum wage, and see whether they fall within the statutory definition of a worker, irrespective of what has been contractually agreed. The modern approach of statutory interpretation is to look at the purpose of a particular provision and to interpret that, as far as possible, in the way that best gives effect to that purpose. In this case, the purpose of the national minimum wage legislation is to give protection to vulnerable individuals who have little or no say over their pay and working conditions because they are in a subordinate and dependent position in relation to a person or organisation who exercises control over their work. So the touchstone of subordination dependence was a degree of control exercised. The greater the control, the stronger the case for classifying the drivers as workers. And the Uber Court of Appeal season was in fact all a dream. So cases, such as the Addison Lee case, which sought to distinguish its position from Uber on the basis of differences in their contractual documentation, have had their permission to appeal revoked, in light of the Supreme Court twist that the statute, not the contract, was a starting point. The Court of Appeal has said that Addison Lee now has no reasonable prospect of success. So, Connie, over to Dynasty.
Yes, now we're going to have a dynasty, as I call it, or a dynasty of obligation. In the dynastic hierarchy of who is entitled to employment law protections, employees are king, essentially, being afforded the greatest level of protection, with the self-employed having very little protection. Somewhere in the middle are those classes of workers who have the benefit of some of the important rights, as we saw in Uber, including national minimum wage, working time, holiday pay, discrimination, whistleblowing protection. Now, when considering whether an individual is an employee, mutuality of obligation, meaning essentially the employer is obliged to provide work and the employee is obliged to undertake that work, is an important factor to establish. But what role does this factor play when establishing worker status? Is there a different benchmark? How do you use this factor? Well, this year in Nursing and Midwifery Council versus Somerville, the AT points out that rather confusingly, the phrase mutuality of obligation has been used in case law in sort of two different senses. So sense one, which properly can be called mutuality of obligation, is simply denotes the exchange of promises or consideration from each party of a kind necessary to create any form of bilateral contract. Sense two, which the court says was better described as irreducible minimum of obligation, refers to an obligation on the employee to accept and perform some minimum amount of work for the employer, who is obliged to offer some work and or pay for the same. So there's sort of two different senses here. And the EAT has clarified that the absence of any obligation on the individual to accept and perform some minimum amount of work in the sense two, which is required to establish employee status, was not fatal to establishing a worker status case. Once a contract is agreed between the employer and the individual to personally perform work on a particular occasion, mutuality of obligation in sense one may be established for the duration of that individual contract. You don't have to have a mutuality spanning different assignments. If during that assignment, there's going to be some mutuality because they're actually doing the work that's been offered. Now, one thing that I think some of my colleagues get fed up with me banging on about is the fact that when it comes to employment law, you have these three statuses of employee, worker, or self-employed. When it comes to tax, it's binary. You're either in employment or you're self-employed. There's no middle ground. There's no worker status. So they tend to become in employment status. So while employment status for employment purposes has these three options, as I said, binary question for tax. Now, in HMRC against the Professional Game Match Officials Limited, the Court of Appeal too had to consider this importance of mutuality of obligation. And in line with the Somerville judgment on employment law terms, the Court of Appeal has held that there is no mutuality of obligation in an overarching contract in the case of these officials, but that didn't mean they couldn't be workers on the actual match days. So they could be in employment for tax purposes, not self-employed on that basis. So now I'm going to hand back over to Siobhan.
And don't forget, finally, delayed from last year due to the pandemic. Since April, 6th of April 2021, existing public sector restrictions on rules related to IR35, which is workers providing services to intermediaries, have been extended to medium and large private sector organisations. Under the controversial change to the rules, instead of the contractor having responsibility to determine their employment status for tax purposes, the client or hirer needs to deal with that assessment, and the client or hirer will have responsibility for passing that status notification down the chain and directly to the worker. The client and other entities in the contractual chain have various obligations depending on the outcome of the status determination and where the entity sits in the contractual claim. These range from administrative obligations to tax and NIC withholding obligations, and could in turn be liable for any missing tax if they get it wrong.
Okay, now we're going to move on to another topic, and this time we're going to have holiday pay. Now, calculating holiday pay should be straightforward, but often has proved to be anything but, running a seemingly endless stream of legal challenges. So sticking with our TV theme and perhaps not the most relaxing of topics or subjects, we're going to have some thrillers set in mysterious and deadly locations as our puns this time. So we're going to start off with what I'm calling the damp squib games. This year, we expected a trio of important Supreme Court judgments, but unfortunately we got under the settled category, the East of England Ambulance Services NHS Trust and Flowers, which was going to concern issues around the meaning of normal pay, and even more importantly, the Chief Constable of Police Service of Northern Ireland against Agnew and others, which concerned a number of issues, mainly relating to a series of holiday underpayments, back pay claims. Unfortunately, both of those claims settled just before they were due to be heard by the Supreme Court. And now, in light of the case in Agnew, this actually leaves divergent positions in Northern Ireland from the rest of the UK when it comes to looking at back pay claims. Under the heading of not yet, fortunately, one of the three important cases has gone and been heard by the court. So the case of Harper Trust in Brazil, Unison intervening, did proceed and was heard by the Supreme Court on the 9th of November. We don't have the judgment for this as yet. This case concerns holiday pay calculations for casual workers. In particular, should holiday entitlement be prorated to prevent term time only casual workers from receiving a disproportionately higher level of holiday pay than full-time or part-time workers who work throughout the whole year. In 2019, the Court of Appeal held that while the pro rata principle for holiday entitlement and related pay does apply in cases of full-year part-time workers, it does not apply in the case of part-time workers, such as term-time-only workers. So if they work a full week, but only part of the year, the same pro rata principle doesn't apply. As such, the often used 12.07% of annualized hours shortcut for calculating holiday pay is unlikely to work for these part-year workers. The calculation set out in the working time regulations must be used, even where it results in part-year workers receiving a high proportion of their annual earnings as holiday pay. And if they only work a few weeks a year, this can be quite a big change. At the time of writing, as I said, there wasn't, the judgments had come down, and I don't think we're going to get a last-minute Christmas present because the court closes at the end of this week on the 17th of December at the time of recording. So likely to get that in the beginning of next year. Now I'm going to hand back to Siobhan.
Lost again. Back in 2017, the CJEU in King and Sash Windows held that a worker was entitled to be paid on termination for any periods of annual leave that they had accrued but not been able to take because they had been discouraged from taking it by the fact that it would have been unpaid. There is no limit on the amount of leave that can be carried over in this type of case because an employer that does not allow workers to take paid leave must bear the consequences. However, the EAT in March this year significantly limited the impact of King. In the long-running case of Smith and Pimlico plumbers, having succeeded that they were entitled to worker status, Mr. Smith has so far been unsuccessful in his main holiday back pay claim. The EAT has held that King does not mean that a worker has a right to carry over payment for annual leave in circumstances where the worker actually took that leave, even though they were not paid for it. So although King establishes the worker is entitled to carry over without limit any annual leave untaken because the employer refused to remunerate it, King does not apply where that leave was in fact taken, albeit unpaid. Now, unsurprisingly, Mr. Smith has further appealed this latest judgment, and that was heard by the Court of Appeal on the 7th or 8th of December, and we are still awaiting judgment as of today.
Thanks, Siobhan. We're now going to move on to our next topic, which is the national minimum wage. Now, the national minimum wage regulations are complex and contain various technical traps which can catch employers out. So we're going to have a look at some of the cases on this, and we're going to lighten them a little bit with some 90s comedy. So we're going to start off with father bed. Treatment of sleep-in shifts for national minimum wage purposes is an area that can often cause confusion, where the worker is required to work a number of sleep-in night shifts at the employer's premises and be available in case of an emergency. Does the full night shift constitute working for the purpose of the national minimum wage, or is the worker only working for national wage payment purposes when they are awake and carrying out any relevant duties? Well, prior to 2018, a number of EAT judgments held many workers were working the entire sleep-in shift, even when they were sleeping. Now, the EAT judgments have significant implications for many care providers. Not only would many employers need to adjust their pay arrangements going forward, they faced really significant back pay claims, as well as potential for HMRC enforcement notices. Now, that position was overturned by the Court of Appeal in 2018, which led to this further appeal to the Supreme Court. Well, good news for the care providers. In March 2021, the Supreme Court ruled in the case of Royal Mencap Society versus Tomlinson and Blake and the case of Shannon versus Rampersad that under the national wage sleeping provisions, an individual who is expected to sleep during their shift and only be woken infrequently, so a sleep-in care worker is only entitled to the national minimum wage when they are actually awake for the purposes of work. So if they have sleep arrangements provided, so they have a dedicated sleep area, and they're expected to be sleeping most of the night, just be woken for an emergency, that does not count. The whole time does not count for national wage purposes, only if they do, in fact, get woken up. So I'm going to hand over to Siobhan for the next one.
Thanks, Connie. And next we're on to only pre-employment fools and horses. Where a worker is required by an employer to undertake compulsory pre-employment induction training, does that training time attract the national minimum wage? According to the EAT, it probably does. A perpetual interpretation of the national minimum wage regulations is required, so time spent completing employer-required pre-employment training may attract the national minimum wage. In Opelcova and Acquire Care Limited, the EAT held that while not yet an employee, individuals who are required to attend induction training were likely to have worker status with the employer during that period of training. As in this case, it will not matter that the individual has not yet started the main job. Indeed, she was not allowed to until she had completed the training. And it did not matter that the main employment contract was not produced or signed until after the training. So Connie, on to the next case.
Yes, so the next one is keeping up expenses, is what we're going with here. So under Regulation 13 of the regs, certain deductions from wages or payments by a worker to the employer and payments by the worker to third parties which relate to their employment, that's the important bit, relate to their employment, must be taken into account when calculating a worker's holiday pay. This is because these deductions or payments will reduce the amount of the total earnings for national wage purposes, except where the employer reimburses or intends to reimburse, and that's made clear. Now, whether an optional payment is related to their employment has been a tricky issue for some time. Indeed, HMRC in their guidance distinguishes between uniforms that are required by the employer to be worn and uniforms that are optional. Now, in Augustine versus Data Cars Limited, the EAT held this year that the correct test is whether the expenditure is, one, in connection with the employment, and two, not reimbursed by the employer. So quite simple. The expenditure does not need to be a requirement of the employment. It simply has to be in connection. It didn't have to be reasonably necessarily incurred, nor even wholly or exclusively incurred in connection with the employment. On this basis, in this particular case, it was irrelevant that the worker was able to use his own car, but instead took the option to lease a car from the employer, or that he had elected to rent a work uniform to enable him to be classed as a gold driver, which allowed him to take a certain level of work, although he could do other work without that. He had clearly incurred both expenses in connection with his employment, and both costs were therefore deductible for the purposes of calculating whether or not he had received the national minimum wage. So employers really do need to be careful to make sure where they've got people who are on or just over national minimum wage, and there's any of these kind of payments, checking that they are going to be compliant. Now I'm going to hand back over to Siobhan for a moment.
Thanks, Connie. Now we're moving on to equalities and human rights. On the equalities front, 2021 has brought us Supreme Court guidance on the shifting of the balance of proof test, a significant development in associated indirect discrimination, an easing in the equal pay comparator tests, and more. So turning to some quizzing and gaming, Connie.
So we're going to start with tipping proof point. Under the shifting burden of proof principle that applies in discrimination cases, it has long been held that the claimant has to initially prove facts from which the tribunal could infer that discrimination has taken place. It is only if such facts have been made out on the balance of probabilities that the burden shifts to the employer to prove that, again, on the balance of probabilities, the treatment in question was in no sense on the protected ground. Now, in 2017, the EAT rather controversially questioned this accepted orthodoxy. Now, in July, the Supreme Court handed down its judgment on the burden of proof issue in the case of EFOBI against the Royal Mail Group Limited, confirming that the established orthodoxy is correct and remains good law. As for the drawing of inferences, the Supreme Court did also emphasize that tribunals should be free to draw or decline to draw inferences in the case before them using their common sense. So while, and I'm going to quote here, no adverse inference can be drawn by the first stage from the fact that the employer has not provided an explanation, it does not follow, however, that no adverse inferences of any kind can never be drawn at the first stage from the fact that the employer has failed to call the actual decision makers. It's quite possible that in particular circumstances, one or more adverse inferences could probably be drawn from that fact. So it's really going to depend on a particular case, what inferences they will draw at that stage. Now, a couple months later, the EAT in the case of Bennett versus MyTech Europe Limited provided expanded guidance on what happens once the burden has shifted. So once we get the burden shifted to the employer to establish that the discrimination has not occurred, in particular in a case where the employer has chosen not to call the actual decision maker or as a witness or at all to the hearing, although they will have provided witness statements. Now, it will be important for tribunals to consider whether the decision maker was available to give evidence. While there may always be documentary evidence sufficient to prove a non-discriminatory reason for the employer's treatment of an employee, the EAT made it clear that not calling the relevant decision maker to give evidence or not providing an explanation for their absence does risk adverse inferences being drawn by the tribunal. And nowadays, if you have distance for the witness, that's not really going to be a good excuse anymore because they can be done by video giving evidence. So things have changed a little bit, so just be careful on that point. So now I'm going to pass over to Siobhan.
Thank you. So have I got associative news for you? Under the concept of associative discrimination, it is not necessary for an employee to be disabled to be able to bring a direct disability discrimination claim, and the claim can be based on someone else's disability with whom they are associated. Back in 2015, the concept of associative discrimination was expanded, at least at EU level, to indirect discrimination. In CHEZ, known as the Bulgarian case, the CJEU held that an indirect discrimination claim may be brought by a person not possessing the protected characteristic. It was enough that that person suffers alongside those who have a protected characteristic, provided the treatment stems from measure which impacts disproportionately due to that group's protected characteristic. So this left a question mark over the indirect discrimination provisions of the Equality Act 2010, which require an individual to establish that the PCP creates a group disadvantage based on a protected characteristic that they themselves possess. In what may prove to be one of the most significant tribunal decisions of 2021, the London Central Employment Tribunal upheld the claim for indirect associative discrimination on the grounds of disability. It concluded that the indirect discrimination provisions contained in the Equality Act must be read as applying to an employee who is associated with a person with a relevant protected characteristic, despite the clear wording in the Act that the claimant themselves have the protected characteristic. In the case of Follows and Nationwide Building Society, Mrs. Follows was the principal carer for her disabled mother. Following a restructuring, the employer decided that senior managers would be required to be fully office-based to provide effective on-site supervision. The tribunal accepted that carers for disabled people were less likely to be able to be office-based than non-carers, and applying CHEZ, Mrs. Follows was put at a substantial disadvantage because of her association with her mother's disability. The requirement was not objectively justified, and therefore the tribunal upheld the claim of indirect associative discrimination. Although this case is only employment tribunal level and not binding on other tribunals, it is suggested that tribunals may be more readily to find that where a PCP disadvantages an individual who has an association with an individual with a protective characteristic, indirect discrimination may be established. Connie, back to you.
Yes, so instead of a lip sync battle, we're going to have some lip service battle now. For the purposes of the Equality Act, anything done by the employee in the course of employment is treated as having been done by the employer, regardless of whether the employee's acts were done with the employer's knowledge or approval. So pretty basic, most people should know that. However, there is a statutory defense available to an employer if it can show that it took all reasonable steps to prevent the employer from doing the discriminatory act or from doing anything of that description. But how does an employer surmount the all reasonable steps hurdle? Well, we knew the bar was set high, and the EAT and LI UK Limited versus Gowling highlights just how high. Employers need to show that they have provided substantial training on discrimination issues, both at regular intervals and on an ad hoc basis if it becomes apparent that prior training was ineffective or has been forgotten. The provision of training on equality and harassment is not simply a tick box exercise. If an employer wants to succeed in winning the employer's defense, it's likely to have to show that alongside any other relevant steps, the training provided to employees was comprehensive, rigorous, regularly refreshed, and is being effectively applied in practice by those who have undergone the training. So it is quite a high hurdle. So I'm going to pass back over now to Siobhan.
Thanks, Connie. We're on to University Challenged. The EAT has upheld in decisions on 2 different employment tribunals relating to the University of Oxford's mandatory requirement age. Whether it was objectively justified, one found it was, and the other found it was not. So compulsory retirement of an individual will amount to an unlawful direct age discrimination unless the employer can objectively justify it as a proportionate means to achieving a legitimate aim. An employer will be more likely to overcome the legitimate aim hurdle in many cases with the legitimate aims of intergenerational fairness, succession planning, and equality and diversity. However, when it comes to the proportionate means hurdle, this is much trickier, although not impossible. The nature of the proportionality assessment means that it is possible for different tribunals to reach different conclusions, even when considering the same measure adopted by the same employer in respect of the same aims. In the 2 cases, both brought by professors who had been refused extensions under the retirement policy, the presentation of the claims and the evidence before the tribunals differed in material respects in relation to statistical evidence and the evidence of detrimental impact. Now, it might be tempting to draw the main lesson from these cases that physics professors are better with statistical evidence than English professors, but the key point is it will all depend on the facts of the case. Connie, back to you.
Thanks. Now we're going to have a bit of didn't give us a clue. With regard to disability discrimination this year, we have learned some lessons. I'm going to just fire out a few of them. So first of all, unlike unfair dismissal cases, in which the fairness of a dismissal must take into account all the circumstances up to and including an appeal, in a discrimination claim, whether a dismissal and the outcome of an appeal against that dismissal are discriminatory must be treated as separate issues. The EAT in the case of Stott versus Raleigh Limited held that the tribunal was right to reject a claim for discrimination arising from disability where the employer only found out about the employee's disability after dismissing the employee, when a post-dismissal grievance was raised. Actual or constructive knowledge of a disability by the employer is required at the time of dismissal in that type of claim. Moving on, the question of whether a claimant's impairments have an adverse effect on their ability to carry out normal day-to-day activities is an objective one that cannot be determined by a claimant's objective beliefs about how to manage the conditions resulting in self-imposed avoidance behaviors. In the case of Premez versus Carroom Restaurants, there was no medical evidence to support her beliefs, and some were contrary to medical advice, so that wasn't sufficient. Also, under the Equality Act 2010, a person is disabled from the date that they have cancer and not just the date on which their diagnosis is pronounced, although a diagnosis often provides the first evidence of a cancer. If a disability is undiagnosed and unsuspected by the employer, it will not be possible for the employer to have had discriminated because of it, because they won't have known about it. On the other hand, if a person does have cancer and the employer believes that to be the case, disability and knowledge can potentially be established before the medical diagnosis. So they're suspecting that they probably do have cancer from what they know so far, and it turns out they do have cancer, then actually they will be covered. And that's from the case of Bennett versus MyTech Europe Limited. So now I'm passing back to Siobhan.
Thanks, Connie. And it's preliminary question time. The EAT, in a very high-profile case of false data, acknowledged in what it refers to as the ongoing public transgender debate between those holding gender identity belief and those holding gender critical belief. The EAT held that gender critical beliefs, including a belief that sex is immutable and should not be conflated with gender identity, are protected under the Equality Act 2010. This judgment is only on a preliminary question of whether a gender critical belief may amount to a philosophical belief under the Equality Act. The EAT concluded that it does. This does not mean, however, that those with gender critical beliefs can indiscriminately and gratuitously refer to trans people in terms other than they would wish. Such conduct could, depending on the circumstances, amount to harassment or discrimination. It is the manifestation of a belief that may, depending on the circumstances, be restricted. What was not open to the tribunal was to impose, in effect, a blanket restriction on a person not to express those views irrespective of the circumstances. Both those holding gender identity belief and those holding a gender critical belief are protected under the law. Connie, next, over to you.
Thanks. The next one we're going to have is the statutory Price is Right. Now, where employers offer enhanced contractual maternity pay to mothers, can they only offer statutory shared parental leave pay to fathers? Does a failure to match contractual enhancement for fathers taking shared parental leave amount to direct or indirect sex discrimination? Well, back in 2019, the Court of Appeal emphatically held that employers who paid enhanced contractual maternity pay but only statutory shared parental pay do not directly or indirectly discriminate against men and are not in breach of the Equality of Terms, equal pay legislation. At the center of this highly significant judgment was the Court of Appeal's conclusion that birth mothers on maternity leave are materially different circumstances to men or women who are on shared parental leave, and this distinction does not simply expire at the end of the 2-week compulsory maternity leave period. Now, this year, we've had Price and Powers County Council, where the EAT considered the same question, but this time the comparison was with an employee taking adoption leave. So it was adoption leave and shared parental leave. And is it discriminating for a male employee on shared parental leave to be paid less than a female comparator on statutory adoption leave? The EAT has again said no, as is the case for those on maternity leave. The predominant purpose of adoption leave is not simply to facilitate childcare, and therefore they were not in the same position as somebody who was taking shared parental leave. So another one to note on that. I'm going to pass back over to Siobhan.
Thank you. On to flexible motherland. The penalty for an employer who unreasonably refuses a request under the right to request flexible working is relatively limited, and there is no mechanism for a tribunal to enforce a request for flexible working, although it can award up to 8 weeks' pay, subject to the statutory cap, if it finds that the employee's complaint is well-founded. However, some employees may also have an alternative recourse against their employer if their request to have flexible working is refused. For example, women returning from maternity leave may be subjected to indirect sex discrimination if their request is refused. This is based on the fact that it is still the case that mothers are more likely to carry primary responsibility than fathers, meaning more women than men need to amend their working pattern to fit in with caring responsibilities. In September, a tribunal in Thompson and Scancrown Limited, trading as Manners, awarded £185,000, highlighting that this is a real risk. A notable feature of the case was that the employer dealt with the request to vary hours by simply repeating a number of the reasons for refusal lifted straight from the flexible working regulations themselves. And this contributed to their failure to get over the hurdle in indirect discrimination claims of showing that their refusal was a proportionate means of achieving a legitimate aim. Connie, back to you.
Thanks, Siobhan. And now we're going to move to some equal pay and what we're going to call the supermarket pay sweep. Most of the large supermarkets are in the groups of large-scale equal pay claims with predominantly female retail shop floor employees seeking to compare themselves with predominantly male distribution depot employees. Now, can private employers avoid equal pay claims through corporate structures that physically separate female-dominated and male-dominated workforces? Well, the answer is simply no. In March this year, the Supreme Court, and as the stores against Briley and others, upheld the decision of the lower courts that a group of predominantly female retail employees can compare themselves to a group of mainly male distribution employees for the purposes of equal pay claims, even though the two groups worked at completely separate establishments, such that no distribution worker would have done distribution work at a retail site, and no retail worker would have done their work at a distribution depot. A comparison could be made because the employer observed broadly common terms and conditions for the relevant groups across the sites. The question is, would the comparator have been employed on the same or substantially the same terms if they had been employed in the same role at the claimant's establishment? Cases that do not pass that threshold are likely to be fairly exceptional. Now, the Supreme Court judgment provides a comprehensive summary of the current law relating to common terms requirement under Section 79 of the Equality Act and a helpful guidance for further cases. Now, while the ASDA case has been decided as a matter purely of UK law, that was really decided under the Equality Act, in addition to common terms tests under the Equality Act, equal pay claimants may also bring a claim under EU law under Article 157 of the Functioning of the European Union. This is known as the single source test. The focus is on whether there was a single source responsible for the inequality that could restore equal treatment. Now, the EU test of single source has always been considered to be wider in its interpretation than the UK test of common terms. And in June, the European Court of Justice in the case of K versus Tesco stores, which was a UK reference submitted before Brexit, confirmed that Article 157 has direct effect in equal value claims. Under the UK common terms test, there was some contractual analysis need for women to demonstrate that there is a valid comparison. The EU single source test sort of cuts through this and creates a simpler, broader test for women to establish a right to compare with a cross-establishing comparator. If there is a single source for the terms and conditions that is responsible for the ongoing inequality and which could restore equal treatment, that comparison can be made. Now, following the ASDA and Tesco cases in September, our tribunal has now held that the retail workers at Morrison's and Safeway supermarkets can compare themselves for equal pay purposes with logistic workers in their employers' regional distribution centers. At a preliminary hearing, the tribunal held that the majority of the claimants were employed on common terms with logistic workers for the purposes of the Equality Act. Further, the terms on which they were employed had a single source for the purposes of the directly effective rights under Article 157. And that was in the case of Abdar against William Morris supermarkets. Now, these judgments do not mean that equal pay claims will succeed, only that the claimants can rely on the terms and conditions of employment of the distribution logistical employees as a valid comparison. The claimants are still required to show that they perform work of equal value, and the employer can still rely on any defenses that are open to it, such as a genuine material factor defense. So these cases are going to continue for some time. I'm going to hand back now to Siobhan.
Thank you. So who wants to be vaccinated? As care home staff are now required to be vaccinated, and frontline healthcare workers will soon be subject to a similar requirement, we have what may prove to be a timely judgment from the European Court of Human Rights. In April, it held that the imposition of penalties for non-compliance with a compulsory national mandatory preschool vaccination requirement for children in the Czech Republic did not breach Article 8, which is the right to private and family life, nor Article 9, which is thought, conscience and religion. The European Court of Human Rights considered that it cannot be regarded as disproportionate for a state to require those for whom vaccination represents a remote risk to their health to accept the universally practiced protective measure as a matter of legal duty and in the name of social solidarity, and for the sake of a small number of vulnerable children who were unable to benefit from the vaccination. So protecting the health of the public can be a legitimate aim, and it can be justified. Now, in the context of COVID-19, this case may suggest that the human rights concerns over compulsory vaccination and status certification may not ban such policies. However, it should be noted that in the Czech case, that concerned childhood vaccination against long-standing diseases and with well-known vaccines. so the exact nature of the vaccination policy and the penalties will be relevant. We're going to move on now to whistleblowing. And under the whistleblowing provisions, the issue of causation has caused the main arguments in whistleblowing claims generally. So we're going to look at a bit of property hunting now. Connie.
Yes. So instead of location, when you're looking at how the whistleblowing cases are being housed at the moment, it's causation. Evidence of a protected disclosure and a detriment or dismissal is not enough to satisfy whistleblowing provisions. There must be a causal link between the two. Significantly, the standard of proof for the causal link differs depending on whether the claim is one of unfair dismissal or one of detriment. To succeed in an unfair dismissal claim, the protected disclosure must be the reason, or if there's more than one, the principal reason for the dismissal. However, in a detriment claim, the worker will only need to establish that the protected disclosure materially, in the sense of more than trivially, influenced the employer's treatment of the whistleblower. The test for causation and detriment claims is therefore significantly less onerous than that applied in respect to dismissals. So this year we've had sort of three cases to note on this. So in Secure Care UK Limited versus Mott, the EAT reminds us there can be no doubt that the causation test to be applied under Section 103A for dismissal and Section 47B for detriment will respectively be distinct. In Kong versus Gulf International Bank Limited, the EAT upheld a tribunal decision that an employee who was dismissed for questioning a colleague's professional competence in relation to the subject of a matter of a protected disclosure was not automatically unfairly dismissed. The manner in which the employee criticized her colleague was properly separable from the protected disclosure as the reason for the dismissal. So you have to really look at what was the cause. It was her criticisms of the colleague unjustifiably, as opposed to the actual protected disclosures. In the case of Oxford Said Business School against Dr. Heslop, the EA confirmed that there was no tension between a tribunal's rejection of an automatic unfair dismissal claim and the finding that a detriment claim was made out. The EAT found that the tribunal permissibly gave different answers to different questions, and concluding that the protected disclosures more than materially influenced the imposition of various detriments suffered at the hands of the whistleblower's line manager, and his subsequent conclusion that the protected disclosures were not the reason or principal reason for the employee's dismissal. So you really do need to get down to causation issues. This is something that when they made the changes back in 2013, everybody was focusing on the introduction of the public interest disclosure element. And we were always saying that we thought the causation was the bit that was really going to come into its fore. And I think that's being proved by the cases we're having at the moment. So now I'm going to pass back to Patricia Vaughan.
So we're now going to look at unfair dismissal. And this year the tribunals have begun to wrestle with the realities of COVID-19 and the related restrictions impacting on dismissal cases. Looking at this through our reality TV picks. Firstly, the masked employee. In Cubilius and Kent Foods, an employment tribunal held that a food distribution company had fairly dismissed one of its drivers who had refused to wear a mask at all times, which was required by the client when the employee was on the client's site. In this case, the employer's employee handbook had expressly required custom instructions regarding PPE to be followed. Connie, the next case.
So we're now going to cover a few different cases under the category of I'm a concerned worker, get me out of here. So Section 100 of the Employment Rights Act provides employees with protection from dismissal for exercising their rights to leave the workplace and take steps to protect themselves where they reasonably believe there is a serious and imminent danger to health and safety. Now, in the case of Rogers versus the Leeds laser cutting, the Employment Tribunal held that to succeed in a claim under Section 100 due to fears about COVID, the employee will need to show that the reason for refusing to return to the workplace was the belief that a serious and imminent danger was posed due to something directly linked to the working conditions, or possibly in traveling to and from the workplace in some cases, not simply circumstances of serious and imminent danger in society at large. So you have to link it to the actual workplace. Now, in September, permission was given to appeal to the AT in this case, although it's currently awaiting listing. Now, also in the case of against Fortuna Group London Limited, the dismissal of an employee, a PPE distributor, who demanded furlough or home working when neither was appropriate, was held not automatically unfair under Section 100. Under Section 101E, a claimant must show not only that they reasonably believe that there were circumstances of serious and imminent danger, but also that he took or proposed to take appropriate steps to protect themselves from danger. The claimant's response was not only that he wanted to stay at home, he was offered holiday or unpaid leave, but he also demanded that he be allowed to work from home on full pay or be furloughed when working from home wasn't appropriate to his role. Now, these demands were not appropriate steps to protect himself from danger, so his claim failed. Likewise, in the case of Moore versus Eoscapes, UK, the employee failed in a claim for unfair constructive dismissal under Section 100 in light of the employee's home working or nothing attitude. In this case, the employee's job could not be done from home, and the employer had put in place significant protective measures for the whole workforce and had offered additional measures to alleviate the employee's fears, but they just simply refused to engage at all. Now, in contrast, the dismissal of an employee who refused to deliver equipment to the home of a manager who was self-isolating due to exhibiting COVID symptoms was automatically unfair under Section 100. The tribunal found that whilst his inexperienced manager was dealing with huge uncertainty at the start of the first lockdown, when a lot was unknown, her reaction to his legitimate concern for his and his family's safety was not excusable or reasonable. And that was the case of Ham versus ESL. Now, also in Gibson versus Lothian Leisure, an employee who was dismissed after raising specific concerns about the lack of PPE was found to have been automatically unfairly dismissed under Section 100. This is the key is that they actually could point to something at the workplace specifically which they were concerned about. Now, please note that employment tribunal decisions are, of course, non-binding on other employment tribunals, but these decisions may be persuasive, and as ever, each case will depend on its own particular facts. But as we only actually really have as we only currently have tribunal level decision, these are good indications of what is going on in the tribunals at the moment. I'm going to pass back to Siobhan.
Thanks, Connie. So now it's time to strictly come furloughing. For employers who undertook a redundancy programme whilst the CJRS was in operation, a number of tribunal judgments have been addressing the question of should furlough or extending furlough have been considered as an alternative for the dismissals to have been fair. Again, employment tribunal judgments are non-binding on other employment tribunals, and each case will depend on its own facts. However, from the judgments that have been reported to date, the trends appear to be: firstly, if an employer simply hadn't considered furloughing staff as an alternative redundancy, a tribunal could decide that their dismissal was unfair. But, secondly, the decision whether to place or keep someone on furlough was a matter for the employer. So provided the decision not to furlough or not considering furlough as a suitable option in a particular case is within the range of reasonable responses, a decision to dismiss by reason of redundancy should not necessarily be unfair. If defending a claim, an employer should set out why it rejected furlough at the time, so it cannot be criticised for not considering it. For example, a public sector employer not eligible for furlough funding. And of course, furlough is not cost neutral. Furloughed staff continue to accrue holiday and service, and delaying redundancies could therefore increase costs overall. Also, the tapering provisions in place at various times meant that employers would be responsible for paying employer NICs and pension contributions and a proportion of the wages for some months. So, Connie, back to you.
So now we're going to move to some unfair dismissal cases from this year that not necessarily in a COVID context. So our next heading is the only way is not an appeal. Generally, to establish that a dismissal was fair, the employer must not only have a fair reason for dismissal, but also to have acted reasonably in treating that reason as sufficient to justify dismissal. In order to act reasonably, an employer must follow a fair procedure, and in most cases, and this remains the case for most cases, allowing an employee a right to appeal a decision to dismiss will be required as part of establishing that fair internal procedure was indeed followed. The relevant ACAS code of practice requires that an employee be advised in writing of the right to appeal when the employer's decision is communicated. But does failing to allow a right to appeal inevitably mean that the procedure followed is unfair? Well, 2 cases this year illustrate that a lack of an opportunity to appeal a decision to dismiss does not automatically result in unfair dismissal. As ever, the touchstone is the reasonable responses test, and the absence of an appeal may be one of the factors to be considered, but it is not necessarily determinative. So we had the case of Moore and Phoenix Product Development, which held that although an appeal would normally be part of a fair procedure, that would not inevitably be so. Whether dismissal is fair or unfair depends on whether, in the circumstances, including the size and administrative resources of the employer's undertaking, the employer acts reasonably or unreasonably in treating the reason for dismissal as sufficient reason for dismissing the employee. In this case, it was quite a senior individual who was not going to change his ways, and an appeal was found not to have made any difference. Also, in the case of against Gwyneth Counsel and Barrett, in a redundancy situation, the absence of an opportunity to appeal does not of itself make a redundancy dismissal unfair. Absence of an appeal is one of many factors to be considered in determining fairness. If the original selection for redundancy was in accordance with fair procedure, the absence of appeal is not necessarily fatal to the employer's defense. In that case, actually, the employees did succeed because of the lack of an appeal, but it was the point. It wasn't the be-all and end-all, so it really will depend on the specific facts, although in most cases it will be required. I'm going to pass back over to Siobhan now.
And we're going to say yes to the process. In Byrne and Alder Hay Children's NHS Foundation Trust, the Court of Appeal considered an employer's obligation to act fairly in the context of disciplinary processes. Now, these were obiter comments, which means that they're non-binding judicial comments, which related to a matter in the case but do not require a decision in that particular case. But those comments indicated tentative support for implying a term into the employment contracts that disciplinary processes should be conducted fairly. And this would be a separate implied term to the general implied term of trust and confidence. While these comments are obiter, it does open the door for this point to be argued in future cases. So whether such an implied term exists and its scope and what protection it would afford to employees in addition to the implied duty of trust and confidence remains to be seen, and this is one to watch. Connie, back to you.
So we're now going to have the crystallized maze. It's settled law that to succeed in a complaint of automatic unfair dismissal for asserting a statutory right, thereby disapplying the 2-year service requirement, there must have been an infringement of a statutory right, not merely an anticipation or threat of future infringement. If an employee, though, is instructed to work in breach of the weekly rest break provisions contained in the working time regulation, when does the infringement occur? So this was the question before the EAT in the Mo's case, and the EAT confirms that an infringement crystallized when the employee was instructed to work in breach of the working time regulations. It was not necessary for the relevant shift or work pattern to have actually been worked for the alleged infringement to have occurred. So it happens at quite an early stage, for one to be aware of. Passing back to Siobhan.
Thanks, Connie, and don't take me out. If a tribunal finds that an employee was unfairly dismissed, in most cases the remedy is a financial compensation for that individual. However, there is the alternative remedy of reinstatement and re-engagement which might be available. However, before making a reinstatement or re-engagement order, a tribunal will consider a number of factors. These include whether there has been a breakdown of trust and confidence between the claimant and the employer, rendering an order not reasonably practicable. In Kelly and PGA European Tour, the Court of Appeal has now confirmed that a breakdown of trust and confidence is relevant not just in misconduct cases, but also where an employer doubts an employee's capability. If an employer is genuinely and rationally believing that an employee is not capable of performing the role, or that their conduct has led to the breakdown in trust and confidence, this will make it impracticable for the employee to be re-engaged, and it is the employer's beliefs that are relevant in this regard. So we're going to move on to a new section now. Connie?
Yes, we're going to have a look at just a couple quick points on tribunal and court rules. And so we're going to turn back to a bit of reality TV for this. And we're going to start with embarrassing bodies of evidence. So under Rule 50 of the Employment Tribunal Rules, the tribunal has the power to make or grant an anonymity order preventing or restricting the public disclosure of any aspect of proceedings as it considers necessary in the interest of justice. And this year we've had a couple reminders that threshold, though, to get such an anonymity order is actually indeed high, and a simple embarrassment on the part of a claimant is not going to be enough. So we have the case of Amia and PricewaterhouseCoopers, where they said that the unruly and disruptive behavior by a claimant at a preliminary hearing held in private does not give rise to the expectation of privacy to support or request for an order under Rule 50. So the fact they acted in a very unruly way in a preliminary hearing doesn't mean that has to be taken out of the judgment. Also, in the case of A against Burke and Hare, fear of future stigmatization due to the nature of the work in relation to the claim relates. In this case, it was exotic dancing, is going to be insufficient. So while the bar is set high, we also had a reminder that there's no general rule that having been named in a public tribunal hearing or judgment, an application for an order under Rule 50 must inevitably fail. In the case of TYU against ILA SPA, the EAT held that an employment judge was wrong to reject an application brought by an individual who was neither a party nor a witness in tribunal proceedings for her name to be removed from the resulting judgment. She was named in relation to allegations of misconduct in a claim by a former colleague. As ever, each case is going to depend on its own particular facts, which will include the particular position of the applicant in relation to those proceedings. And because she was simply named and it wasn't really important to the judgment otherwise, she was able to get anonymity in relation to her mention in the judgment. Passing back to Siobhan.
Thank you. We're on to first date TAS. This one is where an employer learned to its cost that disclosure as part of the employment tribunal claim is different and distinct regime to disclosure of personal data under the data subject access request. And failure to deal with a DSAR simply because there are employment tribunal proceedings ongoing with the same employee does not mean the DSAR can be ignored. In this case of First Choice Selection Services Limited, this resulted in being issued with an ICO enforcement notice. Connie, the next topic is?
We're now going to move on to collective bargaining. Now, 2021 has been an unexpectedly highly significant year in terms of trade union member protection for asserting collective bargaining rights. So employers with unionized workplaces really need to take note of the next couple cases we're going to go through. And here's our pick of the must-know ones as we settle down with some antique hunting. So over to Siobhan for the first.
So now we're going to do a bargaining hunt. Under Section 145B of the Trade Union Labour Relations Consolidation Act 1992, employers are prohibited from making offers to employees where the sole or main purpose is undermining collective bargaining by the union, and that is the prohibited result. But just how wide is the scope of Section 145B? When can lawful variation tip into being an unlawful inducement? Is it enough, as the unions argues, that if the offer is accepted, at least one term of employment will be directly and not collectively agreed, at least for the time being, until the term is subsequently varied or replaced by one negotiated through collective bargaining? Or, as the employer argued, is it restricted to offers which, if accepted, would require workers who are trade union members to agree to forego or relinquish collective bargaining rights permanently? The Supreme Court in Coswell UK Limited and Dunkley and others has rejected both of these arguments as they focus solely on the content of the employer's offer rather than on the prohibited result. The question is whether there was a real possibility that, had the offer not been made and accepted, the relevant term for the period would have been determined by a new collective agreement. If there was no such possibility, then it cannot be said that making the individual offer has caused the prohibited result. So an employer can make an offer directly to its workers in relation to a matter which falls within the scope of the collective bargaining agreement, but only where the employer has first followed and exhausted the agreed collective bargaining procedure. And this is, of course, likely to involve a considerable length of time. What an employer cannot do with impunity is what the employer did in this case: make a direct offer to its workers, including union members, before the collective bargaining process had been exhausted. Turning back to the question of just how wide is the scope of 145B, well, it appears very wide indeed. Though employees do have an ability to lawfully vary terms without it amounting to an unlawful inducement, where collective bargaining has generally been exhausted with all stages of the procedure set out in the collective agreement having been concluded. As such, employers will need to factor in time for collective bargaining processes or face potential heavy penalties. If a complaint is upheld for breach of Section 145B, the award is £4,341, which is revised annually in April, per union member receiving the offer. If more than one offer is made, the award is per offer. So where an offer is made to a large number of union members, the cost can be considerable, and in the case of Coastal, there were two separate offers which were made, and this amounted to just under £440,000 in relation to the 57 union members bringing claims. Also this year, the EAT sitting in Scotland has held that the 3-month time limit for presenting an unlawful inducement claim starts to run from the date the employer makes the offer of the new terms and conditions, not on the later date when the employer indicates its intention to impose the new terms on employees who have refused the offer. And that's the case of Scottish Borders Housing Association Limited and Cornwall. Connie.
Yes, now another unionised workforce case that needs to be aware of is under our heading of the Tulkwa Repair Shop. Now, 2 judgments of the AT this year bring highly significant implications for employers facing industrial action. It has long been common practice for employers to withdraw discretionary benefits from employees who take part in industrial action. Now, employers adopting practices of this kind are now at risk of being held to have acted unlawfully. Instead, they may only safely deduct from the employee's pay an amount that is commensurate with the period for which they were taking industrial action. Now, under Section 146 of TOLCRA, employers are prohibited from to submit them to a detriment for the sole or main purpose of deterring them from taking part in activities of an independent trade union at an appropriate time or penalizing them for doing so. For these purposes, an appropriate time is specified as being outside of the employee's working hours or the time within them where they have the employer's consent, although it's going to be highly unusual for the employer to consent to them taking part in industrial action during work time. Now, the upshot of that is that until now, employees have not enjoyed protection from detriment short of dismissal for taking part in industrial action, for instance, through their employer withdrawing discretionary benefits. In contrast, employees have long had separate protection from being dismissed for taking part in protected industrial action under provisions set out in sections 237 to 238A. Now, departing from previous case law, in June, the EAT, in the case of Mercer versus Alternative Future Group Limited, has held that workers are protected from detriment short of dismissal for taking steps to prepare for and taking part in industrial action. The EAT has held that the protection from detriment for participating in industrial action should be read into Section 146, as absence of any protection from detriment short of dismissal amounted to a breach of an employee's human rights. Accordingly, an appropriate time for the purposes of Section 146 must be read as including a time within working hours when the worker is taking part in industrial action. So now when you read Section 146, you need to read those words into it. Given the implications of this case, unsurprisingly, the Court of Appeal is going to hear further appeal in this case on the 20th of January next year. In a subsequent November judgment, in the case of Moraes versus Ryanair DAC, the EAT confirmed the position was as held in Mercer and added, this same interpretation applies in relation to references to trade union activities if you're looking at claims under the Blacklisting Regulations 2010, and also quite importantly that under both Section 146 of TOLCRA and the Blacklisting Regulations, There is no requirement that the industrial action must be protected industrial action in relation to a trade union. So, meaning an action which the trade union has statutory immunity under tort grounds. So it's quite important judgments. These are going to be further appealed. So really stuff to keep an eye out for and to know what the law is saying at the moment. So I'm now going to pass back to Siobhan.
Thank you. We're going to move on to the next topic, which is contractual terms. And of course, the document related to the contract, which is called the contract of employment, will rarely contain all the terms governing the relationship, because contractual terms are derived from a variety of sources. A contract will be made up of the express terms, the implied terms under common law, statutory terms, and may also contain terms incorporated from other documents, such as collective agreements or work rules. So turning to a bit of detective drama, we are reminded in Sherlocked In that if there is any ambiguity or uncertainty as to whether an employer's express contractual obligation to provide benefits was limited by reference to the specific terms of his insurance, that ambiguity is resolved against the employer and in favour of the employee. In Amdoc System Group Limited and Langton, the EAT reminds employers of the importance of clearly setting out in the employee's contractual documentation that any liability to make PHI payments will be limited to the amounts received from the scheme insurer for that purpose. In this case, the employer was held to be contractually locked in to pay a 5% per annum escalator payment, regardless of the fact that this was not covered by its insurance. Now, this case is being appealed, so one to watch. Connie.
Yes, we're now going to have the line of customary duty. In the case of Thomas and others versus F.W. Farnsworth, trading as Pizza Factory, the EAT provides a useful reminder of the factors to be considered when considering whether an entitlement to enhanced redundancy benefits has been implied over time by a custom and practice. So the guidance says what you're going to have to look at is, firstly, on how many occasions and over how long a period the benefits in questions have been paid. The longer the payments have been made and the greater the frequency, the more employees are likely to understand that these payments were made as of right. Secondly, whether the benefits are always the same. An employer may invariably make enhanced redundancy payments, but if the amounts or the terms of these payments are varied, that's inconsistent with an acknowledgement of a legal obligation. Thirdly, the extent to which the enhanced benefits are publicized generally. If publicized on a workforce generally, and that tends to convey that they are being paid as a matter of obligation. Fourthly, how the terms are described. Payments consistently described as ex gratia are likely to be just that. And finally, what is said expressly in the contract. So no implied term should conflict with the express terms. Now, in this particular case, the employees failed to establish a contractual right to enhanced redundancy payments, while the enhanced redundancy payments had been made on at least 2 previous occasions. On at least 1 occasion, enhanced payments were not made. Also, the calculation of the enhanced payments, which were made on the 2 occasions it could point to, while similar, were not identical, and therefore, and were also described as ex gratia. Therefore, they didn't fall within the custom and practice exception. So I'm now going to pass over to Siobhan to one of her specialist favorite topics of 2P.
Thank you. So this year, the courts have considered a couple of 2P conundrums. So only 2P Connect. When a contract is retendered, services that were originally provided by a single contractor are often divided between 2, 3, 4 or more contractors. And this can lead to difficult questions about whether the original contractor's employees transfer, and if so, where. Until recently, tribunals have taken a fairly pragmatic approach, either finding that the employees transfer to the contractor that has taken the largest share of the services, or that the services are so fragmented that there is no transfer at all. However, the EAT in Scotland has held that the employees' contracts can be split so that they can potentially transfer to multiple employers, not only on a 2P transfer situation, but also under the SPC rules in McTeer, Contracts and Bennett. The practical impact of this may be problematic. Of course, it's usually hard to split employees' day-to-day work between different employers, and it's likely that splitting a full-time contract of employment into a number of part-time contracts will be detrimental to the employee. or it will be so complicated working out how much of the employee's contract will transfer that it becomes impossible. Transferees and transferors should, however, be mindful of negotiating liabilities that may arise in this case, or else setting out a practical solution in these types of situations. Connie, on to you.
Also on 2B, we're going to, instead of having a question of sport, we're going to have a question of legal basis. Under 2B, if a relevant transfer results in a substantial change in working conditions, that is to the transferring employees of material detriment, they have the right to treat themselves as having been dismissed, this is regulation 4.9, and may bring a claim for automatically unfair dismissal. Now, the case of Lewis versus Dallas Silicones UK Limited is a reminder that what may amount to a fundamental breach of a contract for the purposes of an unfair constructive dismissal claim under the ERA, and what may constitute a substantial change to working conditions, the material detriment of the employee for the purposes of Section 4.9 of 2B, are different. In this case, the changes introduced post-transfer to how standby and call-out arrangements work were not a fundamental breach of contract because they could be made within the express term of his existing contract. However, something does not stop being a substantial change just because an employer has the right to introduce it. So I was just reminding that there's two different bases, so he was still able to claim under the 2B provisions where he wouldn't be able to claim in relation to constructive unfair dismissal under the ERA.
Thanks, Connie. We're moving on now to insolvency. And 2021 has brought a number of useful reminders for directors of insolvent companies and administrators of their obligations to collectively consult where redundancies are likely. So we're going to settle down with some teen sci-fi cases now.
So we're going to start with not Stranger Things. In Carillion Services and compulsory liquidation against Benson, the EAT reminds us that compulsory liquidation of itself will not be a special circumstance within the meaning of Section 1887 of TOLCRO, allowing the employer to escape liability for failure to collectively consult before making redundancies. It has long been established that to amount to special circumstances, events must be out of ordinary or something uncommon. Although unexpected by the company, the withdrawal of financial backing by its stakeholders and the government's refusal to provide financial support did not meet the very high benchmark. So it really is quite difficult to fall within the special circumstances defense. Now we're going to move on to the final case that we're covering before we get to our awards. And now I had to, my pun here, I think Siobhan wasn't too sure at first about this one. So I'm just going to say, think Buffy before she says the name Forsey and see if you can understand the pun. Over to you, Siobhan.
Thank you. So we have Forsey, the magistrate delayer. So employers must give notice to the Insolvency Service when they are proposing to dismiss 20 or more employees as redundant at one establishment within a period of 90 days or less. And there are scarcely used rules which make it a criminal offence to fail to notify the Secretary of State in this respect. So magistrates are due to be hearing the criminal prosecution of David Forsey, who is a director, and Robert Palmer, the administrator, in relation to the closure of USC Warehouse, where USC gave the 200 warehouse employees 15 minutes notice of redundancy and did not alert the Insolvency Service. These prosecutions were brought back in 2015, and so far, Mr. Forsey and Mr. Palmer have been pursuing a number of legal challenges to the prosecutions, resulting in years of delay to the magistrates' hearings. In the latest challenge, Mr. Palmer argued that administrators are not covered by the offence, as they are neither officers of the company nor similar to the identified officers responsible, who are directors, managers, or a company secretary. Administrators are not subject to the same duties as other officers and must act in the best interests of external parties, being the creditors. However, the High Court rejected this argument, as an administrator assumes a managerial role in succession to the directors and has all the same powers, including the express power to dismiss the company's employees. And administrators are officers of the company for these purposes. In a second jurisdictional issue, the High Court also held that the English courts do have jurisdiction to hear the prosecution of an employer's directors or officers conniving in the employer's failure to give notice to the Secretary of State of a proposal to carry out collective redundancies, where the affected employees were in Scotland, but the proposal had been formed in England. So we're waiting to hear whether there is an appeal in this case and whether the delay will continue or whether we will proceed to the criminal prosecution. Connie, the time for the awards now.
Yes, so the 2020 awards are please. And we're going to start with the U-Turn Award. And the winner is the Restriction on Public Sector Exit Payment Regulations. Just 4 months after the long-trailed yet at the same time hastily implemented regulations came into force, they were revoked in February. So whether they will come back at some stage, we wait and see. Siobhan?
The next is the Perpetual Extensions Award, and the winner is Right to Work checks. Now, reflecting the unfortunate reality, and while the CJRS gave them a run for the money, the adjusted process for right to work checks to be carried out over video calls, introduced in March 2020, was announced to be closing on the 16th of May 2021, then the 20th of June 21, then the 31st of August 2021, and now extended until the 5th of April 2022. Connie.
Now the shortest ever judgment award, and the winner is the EAT and Atassi versus Stacey Employment Services Limited. In an appeal of rejection of a claim form on the grounds that no ACAS or reconciliation number was given in Section 2, the EAT simply allowed the appeal as, quote, that decision must have been made in error because, in fact, the correct EC number did appear on the claim form. So we're now going to move over to the Nice Try Award.
So the winner here is a city finance worker who unsuccessfully claimed for unfair dismissal in what could be seen as a sexual harassment of equivalent of the dog ate my homework. He was dismissed for exposing his tight underwear to a female colleague on a Zoom call, and he blamed his pet puppy for knocking over his laptop. So, final almost got away with it award, Connie will tell you about.
And this is going to go to, we're going international now, to a hospital worker in Italy for continuing to get paid despite just not turning up to work for 15 years. And if it wasn't for that pesky long service award they tried to give him, he may still be getting away with it to this day. So thank you for joining us for this review of the year. I hope you enjoyed it and noticed some of the cases that are of interest. And later in the new year, we will start with our year preview. So thank you again for joining us.
Thank you.
Thank you for listening to this Gowling WLG podcast. If you liked this episode, please be sure to check out our website, gowlingwlg.com, for more useful podcasts and articles, or please leave us a review on iTunes. Make sure you subscribe to the podcast to join us for our next episode.